Are you and your partner fully committed to each other but unmarried? Have you thought about what happens when one of you dies? Hi, I'm Simon Dippenau and I'm a family lawyer. No one likes to think about death, but it's a part of life. Making sure your assets are distributed according to your wishes when you die can give you a lot of peace of mind. This will be done by making a will, but for a variety of reasons, not everyone leaves a valid will in place when they pass away. If you die without a will, this is called intestacy or dying intestate. The law makes provision for what happens in this situation. If you're married and will have children, the courts will distribute your assets among your next of kin according to an accepted formula. But what happens if you and you are in a life partnership and not legally or traditionally married? In the past, you would most likely have received nothing. This could be particularly problematic if you resided in a shared home, but the property was owned by your partner. Now, in a victory for couples in life partnerships, the Constitutional Court has endorsed a previous High Court ruling that allowed a surviving partner in life partnership with no will in place to claim maintenance from their deceased partner's estate. The court ruled that the Maintenance of Surviving Spouses Act must be amended to ensure the surviving partner can claim maintenance if they can prove they were financially dependent on the deceased. The case first came before the Western Cape High Court, which made the original ruling. At the time, the High Court also declared sections of the Interstate Succession Act unconstitutional and invalid because it excludes partners from inheriting, where partners were unmarried but performed reciprocal duties of support. The Western Cape High Court case involved a woman by the name of Jane Bayana, whose life partner Anthony Rook died interstate. The Interstate Succession Act prevented her from inheriting, but they had been together for some time and planned to marry at the time of his death. She had been financially dependent on him, but her initial claim for the share of his estate was turned down. By the time the case came before the Constitutional Court, she had received her share of the inheritance, but the Court was asked to confirm the High Court's order to ensure justice for all future cases. The decision is not intended to devalue the institution of marriage. The judgment was written by Judge Boisela Bedlanga, who said the institution of marriage is not that fickle. I do not see how giving deserved protection to surviving permanent life partners can devalue marriage. In his view and mine, all categories of families are deserving of legal protection. I welcome this judgment, but to be absolutely certain your assets will go to exactly whom you choose when you die, it's a good idea to make a will, and it should be updated when you marry, have children, or divorce. Don't take chances with the future of your family. If you would like to discuss a will, or if you are in a life partnership and would like to draft a cohabitation agreement, give me a call on 086 099 5146.